So for 2 years now, I've been stating that there has not been a singular case against an AI company in which they've lost a copyright infringement suit. Today, February 11th, 2025, marks the end of my ability to make those arguments with Reuters v. Ross. The U.S. District Court for the District of Delaware has ruled in favor of Reuters in this instance, and they went hard against Ross Intelligence for copyright infringement. Let's dive into this case and talk about the background and the implications of this particular case, because it's kind of wide-reaching. So this case, a bit of background, it started in 2020, and the judge did rule previously on this case, just noting this up front, right? That the judge ruled previously in favor of Ross, and the judge essentially went back and then said, I have a better understanding now of how this technology works, what exactly is going on, and then completely reversed his decision, like went fully against Ross and then fully in favor of Reuters. So it's interesting. So the background of the case, Westlaw is a legal database which is owned by Reuters, and then so Westlaw is the database that's in question here, and then so it contains copyrighted case law annotations and including head notes, and case law head notes is the bottom line here, and the big thing because it's this Ross's model was trained on these head notes from the Westlaw database. And Westlaw has a proprietary key number system, which is how they were able to know that it was trained very specifically on these head notes because the model was aware of this key number system. And so Ross Intelligence, they went to Westlaw initially and they tried to license from Westlaw, but Reuters rejected their licensing. And then so Ross partnered with another company, a third-party company called LegalEase, and that LegalEase company compiled bulk memos, including the head notes from the Westlaw database, and then from those memos, the Ross Intelligence was able to obtain that data and then utilize that in the training of its models. So, and that was one of Ross's arguments, right? It's like that it's so far removed that it's like effects of it are just like several layers removed. And the judge, I'll show you here. The judge ruled against like everything basically, and then so the key rulings by the judge, one are that copyright infringement occurred. That Ross copied 2,243 out of like 2,800 Westlaw head notes, and the judge found direct copyright infringement because the head notes were original and copyrightable, and Ross used Westlaw head notes as training data, making them part of its AI system. Like all of Ross's arguments that like it's not stored in the weights, all of the arguments that I have made a lot on this channel, the judge just threw them out and said no. It was the fact that it ended up in training of the AI system. Like that's enough for me. Like I'm not the law. The judge made like kind of a statement up front. He's like, like the law is like not like a nebulous concept that exists within the cloud. Like it can, shape itself into ways that are needed within these areas, even if it's not like explicitly written. And kind of like it doesn't matter if like you are trying to be sneaky with the way that you are utilizing the way that the law is currently written around these things. It's still like you're doing like you're the intent is what matters here, and that's like what the judge goes a lot off of is like intent, right? And then so all of these rulings boil down to what are the intentions of Ross in this instance. Like, okay, let's strip everything else away. You're saying that you're training, like it's just for AI model training. Okay, but what's the, like, what do you want to use the AI model for? What's the intent? And so the judge, like smartly, right, like refocuses this whole entire debate around intent. So two, he finds that Westlaw's key number system is copyrightable, and that like their key number system is important within this, which it's utilized to organize case law into topics, and then so Ross's argument was that like okay, so even if we did like take all of this data, it's like head notes aren't enough to be copyrightable in and of themselves because they're just head notes. And then Westlaw's argument was that okay, just like they're just head notes, but the way that they're organized within the database and that like the fact that the key number system exists and it's what we have a patent on is makes it unique. And then the judge was like, yeah, sure. So that makes sense, right? Of course. So it rules in favor of Westlaw there. And then the bottom line that the judge rules on is, and this third point here, so Ross's fair use defense. And then the judge finds slightly in favor of Ross in two of these factors, and then in favor of Reuters in two of these factors. And then so he gives it to Reuters in this instance. Like, this whole entire ruling comes down to this third point here, highlighting that up front, and then factor 1 and factor 4 go to Reuters, factor 2 and factor 3 go to Ross. So factor 1, purpose and character of use transferable to against fair use. Ross used the headnotes commercially to build a competing legal research tool, and the use was not transformative because Ross's AI served the same function as Westlaw. So again, going back to that same argument at the end of the day, right? That it doesn't matter. It's like technology replacement. It doesn't matter if you're divorcing yourself from the training data itself. What is that model going to do at the end of the day, right? And I have previously, if this ruling came down 6 months ago, 8 months ago, I'd be in a lot more deep water now. This ruling very specifically targets and harms smaller AI companies that can't afford to have any rebuttal against this, right? And then very specifically, it says if you use legal training data of any kind whatsoever in this particular, that's the broadest and the clearest implication of this, right? Is if you're using legal training data to train your model, or data that would be behind a database. So we can say legal, medical, big industries like that. You're done. This is immediate. In favor of that is not copyright. That's copyright infringement. You will lose moving forward. My assumption is because of this ruling. Don't do it. And then so factor 2, nature of the work compared to slightly supports a fair use. And then so this was in favor of Ross. Westlaw's headnotes have some creativity, but they summarize the judicial opinions, which are public domain. And the judge noted that headnotes are less creative than novels or art, but it still has some originality to it. So that's why it's okay. Factor 2 goes towards Ross, but there's still mitigating factors for 2 enough to go towards Reuters, for the overall decision. And then factor 3, amount of substantiality does support fair use. Ross did not directly copy headnotes into its final product. All of the arguments that I've made over and over, right? It only used them as training data, and courts generally favor fair use when copying happens in an intermediate step. But the judge ruled the factor wasn't enough to override the others. So the judge was like, sure, you can have that argument. You can have your argument. Here's 3 other factors around that, and then you lose on 2 of the other ones, and then you lose hard on 2 of the other ones, and you only win slightly on one of them. And then factor 4, market harm strongly against fair use. Ross's tool directly competed with Westlaw, meaning it harmed the market for Westlaw's research system. The judge did not accept Ross's argument that this tool was merely an innovation. and flat out, the intent, right? If you're building a AI model that's going to compete with a legal industry or a medical industry, etc., it's not a AI device at that point, right? It's competing against whatever company that you're competing with there. In that instance, they make it solid and hard there. Ross's additional defenses got rejected. So Ross's additional defenses were that innocent infringement defense that got rejected. So Westlaw's headnotes contained copyright notices, so Ross could not claim ignorance. Copyright misuse defense was rejected. Ross argued that Thomson Reuters was using its copyright anti-competitively. The judge dismissed this argument, finding no evidence of copyright misuse. And a mergers and scenes defense was rejected, which Ross argued that legal concepts are too standardized to be copyrighted, and the judge ruled that Westlaw's unique wording and structure are protected. So this ruling sets significant precedents in a few different areas, right? I kind of hinted at that, but let's go over what my assumptions are that this is going to impact moving forward. 1, AI training data and copyright law. The ruling establishes that using copyrighted material to train an AI without permission is a clear case of copyright infringement. The judge determined that Ross Intelligence copied Westlaw head notes to train its AI and rejected its fair use defense. Like flat out, it just like the judge pooped all over the fair use defense. This means AI companies must now be extra cautious when sourcing training data from proprietary databases, especially in industries like law, journalism, and academia. Anything that's very proprietary, right? Fair use and transformative AI. The court ruled that Ross's AI was not transformative because it did not add a new purpose or meaning to the head notes. Instead, it used them to create a competing legal research tool. This reinforces that simply using copyrighted content for AI training does not automatically qualify as fair use, especially if it results in a commercial product competing with the original. And that's the important part, right? Like, what's the intent of your main end product? If your end product is going to compete with the original, it's competing with the original, bro. Right? You can't have your cake and eat it too, right? 3, legal databases and proprietary research tools. Thomson Reuters' victory solidifies strong copyright protection over curated legal research tools such as headnotes and classification systems. This could discourage future legal AI startups from scraping or repurposing Westlaw or LexisNexis content, as courts have upheld the editorial curation of legal information as copyrightable. 4, implications for AI companies and data licensing. AI companies might now need to obtain explicit licenses to use proprietary data sets rather than assuming fair use protections. This may lead to higher costs for AI development, as legal AI startups will need to create original data sets or negotiate licensing agreements rather than rely on existing legal corpora. Bottom line with this, so this has been a long time coming, right? And then so with the AI community and the AI research community, we have gobs and gobs and gobs of data sets at this point that there's enough data that exists that you could, and you have, and people have very cleanly trained models of up to any size with data sets that are fully open source, et cetera, that wouldn't fall under these laws and be harmed by this ruling. But when you get into these narrow niches and these narrow domains, like law, very specifically, like law, medical, etc., that's where a lot of these paywalls come in, and a lot of this data is going to be it's going to be a lot harder to operate within the legal AI space overall, very specifically, like as a specific antidote here. And that's probably purposeful, right? Legal precedent beyond AI. This case could set a precedent for other industries where AI is trained on copyright content, such as journalism and news aggregators, academic and scientific research, and music and art. These are going to be the big ones that are affected. And then, the last one, I don't think anyone's going to be crying over, right? But so there it is. And then, so the bottom line, this ruling is a major win for copyright holders and a warning for AI developers. It suggests that AI-generated outputs, even if they don't directly replicate copyrighted content, could still infringe if trained on protected material. The legal AI industry will likely see shifts towards first-party data collection and licensing models rather than relying on scraping or indirect data sources, which is overall a good thing in my opinion. And there's nothing bad about that, although it is important to note, who does this law favor and who does this ruling favor with regards towards the AI companies? It doesn't cut equally, right? It's not just a massive slice across the board. Every AI company is harmed within this. The bigger ones, OpenAI, Google, Microsoft specifically, they come out advantageous within this because they're the ones that can afford to just drag this out and ad nauseum, right? Whereas anyone else couldn't. And then say a smaller company got slapped with this particular precedent, they can't drag it out like those bigger companies could. So this ruling sets a precedent in multiple ways. One, AI training data and copyright law. It very clearly establishes that using copyrighted material to train AI without permission is a clear case of copyright infringement. The judge pooped on everything, determined that Ross Intelligence copied Westlaw head notes to train its AI, and rejected all of its fair use defense. 2, fair use and transformative AI. The court ruled that Ross's AI was not transformative because it did not add a new purpose or meaning to the head notes. The bottom line, like, right, what's the intention? If you're building the model to flat out like compete against and like we're going to disrupt this industry via AI, that's what this law particularly like is against. Legal databases and proprietary research tools. Thomson Reuters victory solidifies strong copyright protection over curated legal research tools such as head notes and classification systems. This could discourage future legal AI startups from scraping or repurposing Westlaw or LexisNexis content. Which I mean, I've already stuck my hand in the cookie jars within this. I understand why this comes about, right? So, cool. Implications for AI companies and data licensing. AI companies might now need to obtain explicit licenses to use proprietary data sets rather than assuming fair use protections. This may lead to higher costs for AI development, as legal AI startups will need to create original data sets or negotiate licensing agreements rather than rely on existing legal corpora. The bottom line is to be a lot more expensive to create these niche type of data sets. And then this does set legal precedent very specifically for music and art. It's the bottom line one, right? And that's the one I don't think anybody's going to cry about. So, like, you have good precedent there for that. But, like, what is this going to be? Like, what's the, like, actual, like, real consequences of this? And the bottom line, like, it's going to be like both good and bad, right? So AI model training is going to require more licensed data, and then so AI companies will need to obtain explicit licenses for training data, especially in legally or commercially sensitive industries like law, finance, and journalism, arts and music, etc. Increased costs for AI startups that need to secure legally compliant data sets that can be seen as a good or a bad thing. More partnerships between AI firms and data providers, which OpenAI is already like they're like that's where OpenAI, Google, etc. They're going to benefit from this because of their partnerships already with LexisNexis, Bloomberg, medical research institutions, etc. No one else has access to that, right? So it creates an artificial gateway into that example. So the winners are large corporations, Google, OpenAI, Meta, because they have their deep legal teams and they have the licensing power, and they own a lot of these data sets already. So losers are going to be small, like all of the smaller AI startups, anyone that relies on web scraping or third-party data sources without clear licensing agreements. And I don't like I get that there is a very small portion of the population that is going boohoo over that particular loser set right there. So I get that. Two, courts will apply stricter corporate rules to AI training. This ruling signals that corporate courts will not automatically accept fair use arguments for AI training. If an AI model uses copyrighted material, even if in an intermediate step, it may still be infringing. And that's the bottom line there, right? Like the judge very specifically poops on that intermediate step argument. Like, and a lot of the arguments like in my previous video on this that I touched on this, and my arguments for years, my book on it, it's all like that intermediate step, right? And then the judge like is like, nah, bro, like, and it's very specifically, like, again, I'm pointing it out, like he ruled the other way on this in 2023. It's like, no, I've thought about this for 2 years now. Like, F you, like, no, like I'm addressing that specifically, and then like here's some precedent, so you can't do that anymore. Like, okay, what am I going to do? And then from that, like essentially your big winners of that though are going to be, again, the big companies, right? So companies, your big publishers, your media firms, and your data providers, your law firms are going to be huge winners here. And then the big losers are going to be AI firms. And then so again, I don't think any sort of there's not a lot of, I don't expect a lot of boohoos over this, right? The third one is AI ethics and regulation will move towards licensing models. So AI development will shift towards licensed and structured data models rather than open source scraping. The winners of this are going to be AI companies that proactively invest in legal compliance. So the ones that have been in jump, right? So again, this might be, it's just pushing towards a good thing. Losers are going to be like anyone that's scraping data. Like if your model is reliant on scraping data, you're not OpenAI or Google or Microsoft, you're out of business. For increased AI model transparency and data provenance requirements. There will be a growing demand for AI companies to disclose training data sources to prove that they're not infringing copyright. And then you're going to see like a lot of this, the winners of this are going to be AI governance platforms that provide data tracking, provenance tools, and compliance solutions. The potential loser of this is OpenAI, depending on how this cuts, right? And then like enforcement is 99.999% of the law. OpenAI is the one that is most susceptible to number 4. How exactly is this? I mean, OpenAI could easily just be exempted, right? So the US AI industry will move toward private data and walled gardens. Bottom line here, we're going to see the winners of this are going to be the enterprise AI companies that offer legally compliant first-party data sources. Like what exactly is going to be the regulations around this? Are they going to be grandfathered in with existing models, etc.? You're going to see a lot of wonky enforcement. My assumption is with this, but we'll see, right? So the losers are going to be open source AI research, as licensing restrictions are going to prevent data sets from being freely shared, and the public is going to lose some access to AI tools trained on like legal data, academic data, and news data. There's a lot of data that is available that makes up for these things overall, and I am highlighting that. So bottom line and final thoughts, the ruling could mark the beginning of the end for AI models trained on freely available internet data. Instead, AI development will shift towards closed proprietary datasets and legally licensed content. The future of AI in the future will be defined by 1. Stricter copyright enforcement against AI training data. 2. A shift towards licensing models for training datasets. 3. More legal and regulatory scrutiny over how AI models are trained. 4. Increased transparency requirements for AI developers. 5. A concentration of power in companies that own the most valuable datasets. In essence, the free-for-all AI boom may be over. Companies that want to survive will need to pay for data or generate their own. Well, I think this is good overall. There's a lot of good things that come from this, and again, there's going to be very few people who are going to be like boo-hoo in any way about this, right? But long term, the worst thing that could happen out of AI is that the Magnificent Seven turns into the Magnificent Eight, and or either the Magnificent Eight or the Magnificent 2 or 3. One of those two things is like the worst case scenario as a result of AI advancement to me, like what we should be making sure that we strive against. And then while this ruling is good overall, if like that is midnight, like if complete consolidation of AI is midnight, this ruling overall moves us closer to midnight on that front. And then so again, like boo-hoo the actual losers within it, but the actual like philosophical framework moves us further away in the end from a way that I think a lot of people will want in the end. So I'm just highlighting that as a result of this ruling. But here it is, Reuters v. Ross. This is huge, massive news. If you like this type of content, please like and subscribe. Thank you very much.